appearing for the High Court.
My lord.
Yes, what do you have to say?
My lord. The relevant portion of the impugned judgment is not back to 28 to lordship.
Yes.
My lord. The punishment order has been set aside on the ground that the disciplinary authority cannot pass the punishment order, my lord, and he may delegate the power to other districts and sessions to passing the order of punishment, your lordship. On this ground, your lordship, the punishment order has been set aside, your lordship. My lord, Rule 17 of Bihar Civil Court Staff Rules 1998, your lordship. It provides, your lordship, the district judge shall be the disciplinary authority of the class 3 and class 4 employee. The district judge may suspend, initiate any disciplinary proceeding, issue a charge sheet, inquire into the charges against the delinquent employee himself, or cause the same to be done by...
Civil Court employees rules teacher, you is referring. Yes.
1998.
My lord. We have followed that. So therefore, he is the disciplinary authority.
He can also pass the punishment order, your lordship, and he cannot delegate.
Not when he is the complainant. Not when he is saying that this clerk has misbehaved with him. Now he becomes a judge in his own cause.
My lord.
No matter even if he was a district judge and he retired as High Court judge. We are in agreement with the single judge's order. Not on the merits of the case, but on the procedure. Now if I make a complaint against my secretary and I will decide that he needs to be thrown out. Which law tells you this? This is the basic.
My lord.
In fact, if I make a complaint against my court master, I will never hear his case. At least justice should be seen to be done, no? And we as judges can't derogate from all this. You have no ground, Mr. High Court.
My lord, the power
Can you deny this? How do you say that the doctrine of necessity could not have been pressed into use? The man was proceeding for Patna to take oath as judge. What was the necessity of passing this order? It could have been given to any additional judge who has the powers of district judge.
My lord.
I mean, I am not on the correctness of the decision. I am on the propriety.
My lord.
No, therefore, I have given you my example. Not that I am speaking against any retired judge. But then if I make a complaint against my court master, do you think that it would appear to be proper that I take a decision and I throw him out of the service? He may be the most indisciplined and incompetent person. All the laws have been thrown to the wind. You are referring to section 17. आप अपनी बहस करिए, हमारे जोर से बोल देने से आप घबराइए नहीं. This is only a tentative observation. आप अगर कुछ दिखाएंगे तो करेंगे.
1998 your lordship, Civil Court Staff Rules
1998 rules. इसमें कौन सा प्रावधान दिखा रहा है?
18 rules.
लिखता है, अपने कर सकता है. District judge shall be the disciplinary authority. He may suspend, initiate any disciplinary proceeding, issue a charge sheet, inquire into the charges against the delinquent employees himself, or cause the same to be done. This is only when he is not the complainant. This is only. He can do it on the complaint of, say, a Siristadar. He can do it on the complaint of the registrar. But don't read a provision like this. All right. Heard, Mr. They are not even issuing notice. Heard Mr. Sanjeev Kumar, learned advocate for the High Court and High Court of Judicature at Patna, who has challenged the order dated 16/8/2018, passed by the learned single judge in CWJC number 16948 of 2007, whereby the order of punishment, the sole respondent, dated 4/11/2006, has been set aside, and a direction has been issued and has been set aside. Sole respondent was a clerk in the judgeship of Sitamarhi, who later rose to become Saristadar with senior selection grade, had misbehaved with the then district judge of Sitamarhi. He was suspended on 15/2/2005 and a disciplinary proceeding was initiated against him with the charge that he procured illegal benefits from the encroachers in the court campus, and when he was asked to remove the encroachment, instead of following the orders, he proceeded on leave, and when the leave application was rejected by the concerned district judge, he visited the residence of the district judge with a request to permit him to go on leave. The further charge against the respondent is that he masqueraded illness, but before that, he exhibited uncharitable behavior which required to put him to departmental proceeding, as his conduct was unbefitting that of an employee of a civil court. From the order of the learned single judge, it appears that he took note of the fact that most of the accusations against the respondent were on the basis of the personal knowledge of the then district judge, who himself had initiated disciplinary proceedings and had framed charges against him. After the inquiry was conducted by the inquiry officer and a report was submitted, he himself recorded the punishment of dismissal of service. The learned single judge has taken note of the fact that the order in question was passed on 4/11/2006, when the then district judge had made an endorsement on the file that he was proceeding to join as judge of the High Court. Nonetheless, the appeal against the aforesaid order was also dismissed. The learned single judge, it appears to us, was absolutely justified in holding that the time-tested principle of natural justice, namely a man cannot be judge in his own cause, was flouted with impunity. And order of dismissal against the respondent was passed. Certain district judge ought to have applied the doctrine of necessity in getting the matter decided by another judge of the same rank, notwithstanding the provisions contained in section 18 of the Bihar Civil Court Staff (Class 3 and Class 4) Rules 1998. The aforesaid rule vests the district judge of a sessions division with a power to suspend and initiate any disciplinary proceeding. He could inquire into the charge himself and could impose any one of the penalties provided under the Bihar and Odisha Subordinate Services Discipline and Appeal Rules 1935. This does not give a carte blanche, CARTEPL, to such district judge to decide in case of his own complaint against an erring official. There could be no more stark illustration of a judge of being a judge in his own cause. It is difficult for us to accept the contention of the appellant that there was no element of bias, institutional or personal, when the district judge recorded a finding of guilt, accepted the finding of guilt, and imposed sentence and imposed punishment, notwithstanding the fact that he had initiated the complaint against the erring official. In the aforesaid circumstance, there was no doctrine of necessity of giving a literal interpretation to Rule 18, where the disciplinary authority is the district judge only. We also find that the order passed by the learned single judge is sustainable on the ground that justice should not only be done but should be seen to be done. There is no reason for us to interfere with the order of the learned single judge, which has set aside the judgment and order, which has set aside the order of punishment by an officer who himself had initiated the complaint against the respondent. The petition is dismissed. Cost लगा देंगे हाई कोर्ट को. You pay cost of ₹5,000. हाई कोर्ट है, दीपक तले मेरा.
नमस्कार दोस्तों, वकील साहब इंडिया में आपका स्वागत है। मैं एडवोकेट वीके आनंद। मुझे आशा है मेरा चैनल वकील साहब इंडिया पर मेरा कार्यक्रम आप रेगुलरली देख रहे होंगे। ये चैनल वकीलों को ही मद्देनजर रखकर बनाया गया है, वकीलों के लिए ही है, ताकि मेरे वकील भाई इस चैनल के जरिए अपनी बात रख सकें। मेरे इस चैनल पर बहुत सारे सीनियर एडवोकेट, चेयरमैन, वाइस चेयरमैन, सेक्रेटरी और अदर मेंबर्स बार काउंसिल ऑफ दिल्ली ने कई बार इंटरव्यू दिए हैं। इसके अलावा अलग अलग बार एसोसिएशंस के मेंबर बार और ऑफिस बेयर जो हैं, उन्होंने भी कई बार इस चैनल के जरिए अपनी बात को रखा है, इंटरव्यू दिए हैं। मेरे लिए बहुत एक्साइटिंग है। मुझे आशा है ये आपके लिए भी एंजॉयबल रहा होगा। मेरी पूरी कोशिश है मैं आगे भी आपको इसी प्रकार के कार्यक्रम दिखाता रहूं। आपका सहयोग और कमेंट्स मुझे एक अलग प्रकार की ऊर्जा प्रदान करते हैं। मुझे आपके सहयोग की जरूरत है। मेरे चैनल को प्लीज सब्सक्राइब कीजिएगा, कमेंट्स कीजिएगा। आपके बहुमूल्य सुझाव मुझे और भी अच्छे ढंग से काम करने की प्रेरित करते हैं। मुझे उम्मीद है आप कार्यक्रम देखना जारी रखेंगे।
नमस्कार, मैं एडवोकेट वीके आनंद आपके लिए और भी ऐसे अच्छे कंटेंट और न्यूज़ लाता रहूँगा। हमसे बने रहने के लिए लाइक करें, शेयर करें, सब्सक्राइब करें और हाँ, फॉलो करना ना भूलें।